Microphone, Mr. Chairman.
Testing, okay. Thank you. You know, as a former teacher, I always say my voice is so darn loud anyway. I don't need microphones. All right, let's everybody introduce ourselves. We'll start this end.
Ellen Martone.
Larry Chapa, Chair.
Dawn Robinson.
Larry Burns.
Stu Miller.
Scott Levesque, Assistant Solicitor.
Marty Loisel, zoning official.
And before we do anything, I would just like us to take a moment of silence in honor of our former chair, Walter Porkawish. I wish he was here to hear that I finally learned how to pronounce his name. But if we just take a moment of silence, he passed away recently. Thank you. Next, we have the approval of the minutes from February 11th. May I have a motion? All those in favor? Opposed? Carried. Are there any changes to the agenda?
No, but I just want to point out that Chloe is not here tonight. She's down the hall taking the minutes for the finance board meeting. They don't do audio video recordings, so
Okay.
please speak clearly into the microphones, and in particular when you're making a motion or seconding a motion, so she gets the record
Okay,
correct.
when we make motions and seconds, please state your name so that she knows it in the, when she hears it, okay? Good evening and welcome. The Zoning Board of Review has established procedural rules and guidelines for the administration of applications and the conduct of its meetings and public hearings. The rules of procedure amended in December of 2021 are posted on the town's website and are available here tonight. The Zoning Board hears applications for relief from the provisions of the zoning ordinance and renders its decision based on specific facts found in the documents and testimony submitted. It is the applicant's burden to prove that relief from the zoning ordinance is warranted. To do so, an applicant must provide evidence that each criterion of approval listed in Section 260-33 for variances and Section 260-34 for special use permits have been met. If you are appealing the decision of the zoning officer, administrative officer, or planning board, you are here to convince the board that the officer's or board's decision was an error, either procedurally or legally. This evening, there are 3 things on the agenda, but only one of them will be heard tonight. We do not take up a new item after 9 o'clock. Each application shall be heard in a manner that permits the board to obtain and consider the evidence in an orderly and meaningful manner. Testimony begins with the zoning official's summary of the application and his recommendation. The application and all documentation submitted by the applicant prior to the meeting will be marked as exhibits and made part of the record. Applicants should assume that the members of the zoning board have received all the materials submitted with the application. Tonight's presentation by the applicant should be limited to information relevant to the burden of proof and not recite or repeat information already submitted with the application. Any new information received by the board this evening will be entered into the record. However, the board retains the right to continue the public hearing to fully digest any information presented. All questioning of witnesses shall be done at the discretion of the chair. All questioning of witnesses shall occur when the witness is called. The proponent of the witness shall ask its question. Interested parties shall then ask the witness their questions, and the proponent may ask follow-up questions. Presentation of an affirmative case by any interested party other than the applicant will be allowed as part of the public hearing following the application's presentation. Continuation or closing of the public hearing is at the discretion of the zoning board. And our first order of business tonight is 2 Gray Cats Properties, 18 Franklin Street. Will the person Bob, with that, please come up. And Marty, could you fill us in?
The applicant, Michael Maloney, is requesting to amend the 2017 special use permit to allow a residential use on the property in an existing detached structure. The previously approved special use permit authorized the change of use from a mixed-use development to a spa boutique with a condition set forth not allow for a residence. The applicant is seeking to remove that condition and have a legally established residential unit pursuant to section 260-34 special use permits and 260 attachment 11 zoning district use tables, use code A.18 mixed use development of the town of Westerly zoning ordinance. The subject property contains 21,000 square feet, 0.48 acres, and is in the professional office P15 zone. The surrounding neighborhood consists of professional office 15, P15, high-density residential 6, HDR 6, and open space and recreational zones. There are no wetlands on the property, and it is not in a flood zone. The property contains a 2,668 square foot office building, which was constructed in 1926, along with the 528 square foot outbuilding to be used for the proposed residential unit. The zoning department supports this application. The proposed residential unit will occupy an existing structure, will not bring any additional traffic to the area, or create a nuisance for the neighbors. The proposed special use permit amendment does not increase development, require new construction, or create adverse impacts on surrounding properties, traffic, public, or services. It is a reuse of an existing structure. Residential uses and mixed-use developments are permitted uses in the P15 zone. In 2020, the applicant received a permit to finish the interior of the existing two-car garage for additional space for the spa. It was essentially an open area with a bathroom and a sink. At some point, a kitchen was added and the space was converted to a residential unit without permits. The applicant is now taking steps to legalize the unit.
Thank you. Sir, your name, please?
Michael Maloney.
You're Michael Maloney?
Maloney,
Oh, okay, and you are the applicant?
I am.
You are the applicant, okay. Can we have the gentleman sit at the table? Yeah, usually that's the best way.
Sure.
Yeah. Okay. So why don't you fill us in a little bit about why you're here?
Well, we've had a spa there for maybe 8 years. My wife had one prior to that in Westerly, right down the road. We bought the Sarazolt house, which was a dentist and a
I'm gonna
house.
stop you. Is that microphone on? It's on? Okay. Yeah, get it closer to you.
Is that
now.
better? And during the construction of the spa, when that was finished, I started working on the garage. And when I had electricians there and plumbers, I did get some permits, but a few permits I didn't get. So I'm going to move forward to doing that. I've been using it for an Airbnb for the last 2 years. Then I recently found out that there's a $500 charge for an Airbnb, which I need to pay, back pay that, get caught up on that. So that's what I wanted. That's what I need the residential for, because it's commercial property now or professional, and I need to get residential in there.
I may have misheard you. Did you say you've been using it as an Airbnb?
I have been.
You have been, without getting the permits or anything?
Well, I had the permit from the state. I got the permit from the state to have an Airbnb. And we do have overnight stays at the spa. We have that, like wedding couples, if they wanted to stay over, they would stay there. So now that I know that there's a charge for the Airbnb, I'm going to start paying that and finish getting the permits that I need to make it legal.
So you're coming to us now for why you didn't come to us before you did. You're coming to us now. Why is that? Why did it take so long?
Well, I didn't know about the $500 charge until this year. I did pull summer permits for the water, the sewer, the air conditioning, some electrical, but I didn't apply for a kitchen. So when I installed a kitchen,
But the garage is not approved for residence at this point, correct?
correct,
But you've been using it as a residence.
correct.
Why?
I was told because it was professional business that I could do anything I wanted on there.
But you've been to us before, and I remember when we approved your spa, it specifically said no residence.
Well, there was overnight stays were allowed in the spa.
Well, that's news to me because it's a residence. Anyway, let me ask, anybody here have a question? Any questions or, go ahead, Larry.
I wasn't here at the time. One question I had was, why specifically was a residential use excluded from their original special use permit?
Marty, could you answer that?
There were initially 2 apartments in the main building on the 2nd floor, and they eliminated those to expand the spa space. And it was just, what was being proposed was strictly a spa with no residential use, so they kind of codified that in the decision.
Go ahead, please.
Okay, so I just want to clarify. So we had this property. We agreed that we were going to change it to have the spa in the back. You applied to permits at the state level to get the Airbnb,
Yes,
to get overnight. And at the time, you weren't aware, or you were aware that you needed to have permits here for the kitchen? Because it sounds like it's an issue of the kitchen. The kitchen just wasn't there, and then the kitchen got in.
Yeah, I mean, he got permits to finish out the space for the spa. So, I mean, it had, the bathroom, the sink, sheetrock, air conditioning.
Yeah.
That was all permitted. But the addition of the kitchen, and there's a Murphy bed that folds out of the wall.
we put a Murphy bed in there.
So you, as far as you knew, you had the right to use the property for overnight stays for weddings, or did you just do that because you had it?
We were using it for overnight stays, but then I decided to use it as an Airbnb because we weren't getting a lot of weddings. So then I applied for an Airbnb permit to have an Airbnb there
At the state level?
at the state level. Got a permit from them.
And how long has that been?
Maybe 2 years.
And so how did we figure out that there was a kitchen?
I believe what happened is the town has new software now that finds short-term rentals online through Airbnb, Vrbo, and stuff like that. And they picked up that it was advertised. It got flagged because they'd never gotten a short-term rental license, and then he got a letter. And that's what got the ball rolling on this.
Got it. Okay. Yes.
Anybody else have anything here? Please, go ahead.
I'm sorry, can you turn on your microphone? Just so that we
I
have a
keep
record.
forgetting that. Is a residential permit or a residential zoning different than what he was doing before with a,
It's an allowed use. He doesn't need like.
so basically.
The reason he's here is because of the condition in the
Yeah.
decision.
So basically, though, he wasn't using it as a residence. He was just using it for overnight for his business.
Right, but he could use it, he could have a long-term.
Yeah.
Right, but it's not an accessory dwelling unit, an ADU. That has certain restrictions on short-term rental. You can't do that. This is just straight up
Straight up.
unit, residential
So
unit.
at this point, it would seem to me, as long as he obtains the proper inspections from the town and the fire department to make sure
Right,
that.
yeah, I believe he still needs inspections from the building
Yeah,
department to make
okay.
sure everything's up and on the up and up.
Anybody else? I guess I didn't know that a spa, I never saw a spa that had overnight, you could sleep in it. It's of course, I have a lot of experiences with spas. but-
Norwich and Spa. and other
Norwich,
spas have it.
yeah, the Norwich Inn, yes. I bought my wife plenty of, what do you call it, gift cards to the Norwich Inn, and they're expensive.
Oh, I guess what bothers me is that you've been flaunting the restrictions on this for 2 years. And that really bothers me. It really bothers me because you're an intelligent man. You knew what you were doing. You really did. We have rules for a reason. And you got caught.
When I found out from the town, then I came in and had this
You got
conversation.
caught. You got caught. All right. Well, anyways, if anybody has any other questions, I'm going to poll the board on this, okay? Let's start.
I'm sorry, Mr. Chairman, we should, there is somebody in the audience. We should
Oh,
open up the
I'm
audience.
sorry. I forgot. Is there anybody here thank you. Anybody here who wants to speak in favor of this, against this, or needs more information? Okay. Thank you very much. Yeah.
Okay, I'm in favor of this application.
I'm on the fence.
I'll come back to you.
I'm opposed to it. Alan Martone.
Thank you. As you go through this, we'll state your names. Go ahead.
So I am definitely on the fence simply because we have something that says we're not supposed to approve things that somebody's already been doing. That's against the law. And I guess I would like to have more open dialogue about it. I'm kind of like Lori.
We'll come back. I believe go ahead, Scott.
Yeah, I don't want to interrupt the process, so I think we should finish the polling, and then I'd like to give my 2 cents from a legal perspective.
Larry?
So in respect to Larry's hesitancy here, I understand that point. The cart before the horse, I think it's an unorthodox way. Whether the motivations were misunderstanding or deliberate, I think is immaterial to what we're discussing tonight. I think that had that not happened, the use is compatible with the town's comprehensive plan. I think we would waive it through unconditionally otherwise. I think the thing that keeps people from doing that is not us approving a misdeed. I think if anybody invests a lot of money into a place without having that permit, it gets flagged, it comes before this board, we can very easily say no, and all that money they've invested could be for naught. And I think that potential penalty, in my opinion, is the thing that keeps people from doing that, not us saying yes or no or setting precedents on our level. And I would also say, and I don't know to what degree this weighs other than the compatibility of the current use with the neighborhood, but I do business at that horrible bank across the street regularly. And I find that their spot is a real improvement. They've done a really nice, tasteful job with it. It's different than a lot of places in the Route 1 corridor. And I think for that warms my heart towards the entire application because I think it's a year-round business. It brings tourists and people, and I think it's a good use. And so I'm in favor of it, despite your reservations, which I completely understand.
I completely agree with everybody on this board. Larry brought up a good point in regards to monetary investment. We're supposed to be promoting investment opportunities for everyone here. So I fully believe that. I also agree with you, Trim, that it was a, shame on him, obviously. But I am in favor of it because it is the money investment, as Larry brought up, that it's in our town. So, and it's already there. So it's not like he's adding or subtracting. He's just building upon it and trying to use it in a different fashion to increase money.
Scott, did you want to?
Yeah, I'd like to weigh in. I just want to remind the board that if this were a variance that was being sought, then certainly I think what the board is contemplating is a tenet of variance law, which is if you create your own hardship, you're not entitled to the relief. And often you would see that if, somebody, tore down a deck and then built a new one that was inside the setback and then came to you and said, well, now I need a variance. Well, you've created your own hardship. But that's not the situation you find yourself in. And this is a distinction that is important because when you're talking about a special use permit, you're talking about a permit that, a use that is permitted by right, okay? That's where you start with. And the reason why the town reviews it at all is to check to see if it meets specific and objective criteria that the town sets out to govern, okay, now that we're gonna say you have the right to do that use, we wanna make sure you're meeting these specific and objective criteria. So this isn't that situation where you're talking about a variance that if he creates the hardship, he can be penalized for it. That's not the situation. This is a situation where he has the right to do the use. We have specific and objective criteria you're supposed to weigh, but those are merely to help guide the ultimate decision to make sure which ones do we need, which ones don't we, to govern the use, but the use is still permitted. So this isn't one of those situations that, you know, doing it for 2 years is a pox on his house. It really isn't. It's not a good look, and I can certainly understand the board's view on that, but it's not part of the criteria that you can consider in denying this project or granting it. It's merely, this is a special use. Does it meet the specific and objective criteria? As long as it does, then you should be granting it. It's not that variance issue that you're probably thinking about. So just want to make that clear.
Okay. I'm going to re-poll the 5 members that are actually going to be voting on this. Okay? So,
Okay, state my name.
um,
Leonard Saponari, I'm in favor of the application.
yeah, Lauren?
I mean, after hearing what you've said, I'm in favor. I was just looking at the decision, didn't say anything about overnight stays. It just says accessory building to use for various health, nutrition, and yoga classes. That's my only point. Other than that,
You're in favor.
I mean, yes.
I'm still opposed.
Okay.
Alan Martone.
Dawn Robinson. So I'm sorry, I'm going to have to oratorily work through this and you're just going to have to listen to me noodle. Sorry, guys. Okay. So I do agree that the property has added a lot of value to the street. It is lovely. There's a nice business. There's a lot of people there. I am morally opposed to somebody not coming before their neighbors and saying, I'm doing this. However, I think it's a waste of time to put ourselves in a position where there's a lot of court and then it comes back and we have to do another round of this. So if that would happen, I do agree with, I mean, we are trying to make people stay in our town and make money. And that is a very nice spot for the summer crowd. So I just want to check in. Can I check in one more time? Can I check in one more time with them?
Do anything you want, yeah. Still open.
So I just want to confirm that you went back to the state after you came to this board. Did you go to the state to get the Airbnb after you were here?
Maybe like 3 or 4 years after that.
Okay. So there was forethought on the fact that you were going to do this Airbnb. You went to the state, you got a permit from them, and then basically got caught by the town, which I'm pretty happy about, I got to say, as a taxpayer. And now you're going to have to pay back all the, because I'm self-employed and I have to pay money to work out of my house. So I'm very familiar with the process and I know what the fees are. And you are going to have to go back and pay all of that back, correct? Are we correct in that assessment? We're going to have to go back and pay back all the fees that have not been paid?
Yeah, I mean, that's up to Mary to decide what he owes for the short-term rental.
Okay, so
Clerk issues the
from the
license.
stance that I think that I don't want to have to go through this again. And I do think it is a permit that is permissible on the property. I would be in favor of it, but I'm really hoping that nobody ever comes back and asks again. That's my position, so I'm in favor.
And Larry, you already said you approve, right? We need what, 3 yeses? All right, so I'll be honest with you, just for morality purposes, I'm going to vote no, but you're going to get your three yeses, so. No, Lori. You and you, okay? I just won't give you the satisfaction of a full,
Leonard said yes.
yeah, but they're not a full member, so, yeah. Okay, so at that point, then, I'm going to ask for a motion to close the hearing. That would be Dawn.
Dawn?
Okay. All those in favor?
Aye.
Closing it. Opposed? Carried. All right, I'm going to turn it over to Larry.
Mr. Chairman, we have before us a request by Michael Maloney, who is requesting to amend the 2017 special use permit to allow residential use to the property in an existing detached structure. The previously approved special use permit authorized the change of the use from a mixed-use development to a spa boutique with a condition set forth not to allow for a residence. The applicant is seeking to remove that condition and have a legally established residential unit pursuant to section 260-34 special use permits and 260 attachment 11 zoning district use tables, use code A18 mixed use development of the town of Westerly zoning ordinance. The subject property contains 21,000 square feet with 140 feet of frontage on Franklin Street and is in the professional office P15 zone. The surrounding neighborhood consists of professional office P15, high density residential HDR6, and open space and recreational zones. There are no wetlands on the property. This is not in a flood zone. The property contains a 2,668 square foot commercial building, which was constructed in 1926, along with a 528 square foot outbuilding to be used for the proposed residential unit. The zoning board hearing was held on March 11th, 2026. Zoning board members, Chairman Lawrence Chapa, Vice Chair Don Robinson, Larry Burns, Alan Martone, Lori Moore, alternate Leonard Saponari, alternate 2 Stuart Miller were present and heard testimony during the entirety of the public hearing. The zoning board was provided a narrative by zoning official Martin Loisel dated February 5th, 2026, which outlined the details of the application and was summarized by Mr. Loisel at the March 11th public hearing, thereby made part of the record. Michael Maloney spoke as himself the applicant. No individual spoke during the public hearing in support of the request or in favor of the request. During the public hearings, no further testimony and materials were entered into the record. The following plans and specifications are hereby made part of this approval and may not be altered, amended, or changed in any material way unless approved by the Westerly Zoning Board of Review. The determination of whether any alteration, amendment, or change in the approved plans is material shall be made by the town zoning official and the zoning board chairman. The zoning board hereby grants the zoning official administrative authority to approve further non-material modifications to its approved plans. Site plan special use permit, Michael and Rose Maloney, AP 87, lot 155, 18 Franklin Street, Westerly, Rhode Island. One sheet prepared by National Land Surveyors Developers, Inc., stamped by Norbert A. Theron, number 1739, dated December 20th, 2016. Mr. Chairman, through the public hearing process, the board heard that the applicant's request for a special use permit is based on the applicant's desire to utilize an existing structure as a complementary residential unit to their spa business at the same address. Considering the information presented at the public hearing, it is my opinion that the applicant has satisfied the standards of section 260-34 special use permits, whereby the granting of the special use permit will be compatible with the neighboring uses and not adversely affect surrounding neighbors' use and enjoyment of their property, because it will utilize an existing structure that will not increase traffic or noise in any appreciable way. 2, that the granting of the special use permit will not alter the general character surrounding the area or impair the intent or purpose of this ordinance or the comprehensive plan of the town. In reaching this conclusion, the board has considered and finds that satisfactory provisions and arrangements have been or will be made concerning, but not limited to, the following matters where applicable. A, satisfactory ingress and egress to the lot and to the existing proposed structures thereon, traffic flow and control, and access in case of fire, emergency, or catastrophe has been shown because the site currently provides for this access. B, satisfactory off-street parking and loading areas, pedestrian and bicycle circulation, and convenience has been shown by the site provides ample parking for the applicant's intended uses. C, satisfactory noise, glare, or odor effects of the special use on adjoining lots has been shown by the intended use should not generate these types of nuisances. D, satisfactory location and maintenance of trash, storage, and delivery areas as demonstrated by the applicant's business currently addresses these needs adequately. E, satisfactory utilities with reference to locations, availability, and compatibility is demonstrated by their current existence and utilization. F, satisfactory screening and buffering with reference type, dimension, and character as evidenced by current landscaping and fencing provide the necessary privacy. G, satisfactory signs, if any, and exterior lighting with reference to glare, traffic safety, and compatibility and harmony with lots in the zoning district has been shown by current signage and lighting is attractive and compatible with the area. H, satisfactory required yards, landscape, and other open space is proven by the residential unit will occupy an existing structure and does not require any additional space. I, satisfactory soil erosion, water supply protection, wetland and wildlife protection has been addressed and as shown by the property does not appear to be close to an environmentally sensitive area and it appears to be compatible with its environment. J, satisfactory general compatibility with the lots in the same abutting zoning districts as seen by there are many mixed-use properties in this P15 zoning area and the use is compatible with the town's comprehensive plan. K, satisfactory protection of the property values as evidenced by, since owning the property and converting it to a spa, the applicants have made many improvements, and it's one of the more attractive properties in the Route 1 business corridor. The business also contributes to the year-round economy and should have a positive effect on nearby real estate values. That all best practices and procedures to minimize the possibility of any adverse effects on the neighboring property because the applicants have made a significant investment in the property and in their business, thereby demonstrating a commitment to enhancing the neighborhood. As such, Mr. Chairman, I move to approve the special use permit application, which proposes to amend the 2017 special use permit to allow residential use on the property in an existing detached structure pursuant to section 260-34 special use permit and 260 attachment 11 zoning district use tables use code A18 mixed use development for the town of Westerly zoning ordinances with no additional conditions.
You have a second?
Second,
Okay, we'll take
Dawn,
it.
second, sorry.
We'll take an individual vote on this, starting with Lori. Yes or no?
Yes.
Okay.
Alan Martone, no.
Larry Chapa, no.
John Robinson, yes?
Larry Burns, yes.
Okay, with 3 yeses, it is passed. And you're done.
Thank you.
So do we have to do anything on the things that are,
You have to vote to continue them to the April 8th meeting.
I'm
Correct.
sorry, I didn't
You
hear.
have to vote to continue the 2 appeals to the April 8th meeting.
Okay, we do them individually?
Yeah, they're 2 separate applications.
Okay, so I'm going to need a motion on the application by Hinckley Allen on behalf of the R.H. McClade family to move it to our April meeting.
Second?
All those in favor?
Aye.
Aye.
Opposed? Carried. I will need a motion for the Pierce Atwood on behalf of their clients at 4 Spray Rock Road to move it to the April meeting.
Dawn?
All those in favor?
Aye.
Okay. Is there any other business, Marty?
No, that's it.
Okay, then I'll just need a motion to adjourn.
So moved.
Dawn? We have a second? Lori? Second? All right, Alan. Okay, gentlemen, ladies, we're done. Scott?